Hi, Assalamualaikum. Today, I will present to you the group project assignment for course ICM662 Information Security Management entitled Cybercrime in Law and Ethics. Next, I will introduce to you our team members. The first one is Mohamad Ariff Aiman bin Mohamad Napiah. The second one is Alya Najwa binti Mastuni. Next, Aiman binti Rosli. And the last one is Yasmin Natasha binti Maswari. In this slide, I will explain about the definition of cybercrime and ethics. Okay, what is cybercrime? A cybercrime is a high-tech or computer crime, which is any crime that is perpetrated or performed using a specific knowledge or expert use of computer technology, which is explained and defined. Moreover, an ethic defined as an ethical issue that should also coexist with progress, and this is also true for information technology, which namely known as IT, which refer to as a subdomain of technology. Okay, this purpose of study, we do a deep research into cybercrime in law and ethics in Malaysia. This study also aims to learn how the law and ethics could be underpinnings of an effective security and risk management program and issue cases related to it.
Assalamualaikum, my name is Aiman binti Rosli. I will presenting about one of the act that related to our topic, which is Anti-Fake News Act 2018. Anti-Fake News Act 2018 was published officially on 11 April 2018 and was passed by the Malaysian Parliament on April 4. Also received royal assent on April 9. Based on the Act, fake news can be defined as any news, information, data and report which is wholly or partly false, whether in the form of features, visual or audio recording, or in other form capable of suggesting words or ideas. In short, the purpose of this act can be introduced because the law is not intended to restrict freedom of speech but to restrict the dissemination. They also have a quite similar to this act in other countries such as Thailand, Indonesia, Singapore, Vietnam and more. Okay, then the Anti-Fake News Act 2018 contains 14 sections, which is section 1, 2 and 3 preliminary. In this part, the act briefly explain about the commencement definition used in the article and extraterritorial application of the act. Next section is 4, 5 and 6 section is about the offences. They are also include the example of situation which can cause the offences. Section 7, 8 and 9 is about the order for removal of publication containing fake news. And section 10 until 14 is miscellaneous like abetment, institution of prosecution, seizable offences by body corporate and power to amend schedule. After that, we have issues that can use in Anti-Fake News Act 2018. The issues is based on Section 4 of Anti-Fake News Act 2018, which is creating, offering, publishing fake news and publication containing fake news. The issues is happen during the pandemic of COVID-19, where there are a lot of people publish fake news information on social media, such as about the traditional medicine that can cure the virus like clove tea and habatus sauda. They also create fake news to scare people using WhatsApp and spread fake news about vaccination, which is who take the vaccine, they could lead to death. According to Section 4, the punishment could be maximum fine in 500,000 ringgit and imprisonment not more than 10 years or both. In case continuing the offence, further fine not exceeding 3,000 ringgit after conviction. That's all from me. Thank you.
Next, Copyright Amendment Act 1997. A copyright is a sort of intellectual property that grants its owner the sole authority to reproduce, transmit, adapt, exhibit, and perform a creative work. The creative work could take the form of something musical, artistic, educational, or literacy. A creative work's original expression of a concept is what copyright is meant to protect. The Copyright Amendment Act 1997, which revised the Copyright Act 1987, went into effect on April 1st, 1999. making it illegal to transmit copyrighted work over the internet. The Amendment Act's primary goals is to give multimedia works intellectual protection. A person guilty of an offence under this action shall, on convincing, be liable to a fine not exceeding RM25,000 or to imprisonment for the term not exceeding 3 years or to both. There are example copyright cases in Malaysia. The first one lawsuit is in 1999. The local recording organisation filed a lawsuit in May 1999 against Wilayah Computer and Sony Music Entertainment. The Ministry of Domestic Trade and Consumer Affairs (MDTCA) decided to permit the filing of test case in which claim of copyright subsistence would be supported. The second one is lawsuit in 2005. The Recording Industry Association of Malaysia's lawsuit against a shopping centre in the heart of Pahang for renting out its space to VCD pirates is a recent example of a copyright case. For instance, a criminal was sentenced to 3 years in prison and RM7.3 million after being found guilty in court. Awareness on copyright among students. Based on Injudia and Hamzat 2016, the high cost of textbook, ignorance of the concept of plagiarism, free internet copying, peer pressure for academic research, easier access to the information required, ignorance of what is right or wrong on the internet, and misunderstanding of copyright law as it relates to internet content were the cause of copyright infringement. Other than that, Cha Bono and Priest 2014 said because of educational institution lacks of copyright specialists, people's lack of awareness of this issue is exacerbated. In order to prevent widespread infringement when students are engaged in the process of producing their own work, institutions and educators need to be more diligent in instilling suitable attitude toward copyright law.
Hi, Assalamualaikum. My name is Nur Alya Najwa. In my part, I will explain about the Personal Data Protection Act 2010. The Personal Data Protection Act 2010, or namely known as PDPA, are the Act 709 that was enacted by Parliament on May 16, 2011, which led to the creation of the Personal Data Protection Department (PDPD). It is founded under the Ministry of Communication and Multimedia Commission, which is namely known as MCMC. The Act was introduced in Malaysia to increase customer confidence in commercial dealings and e-commerce, given the rising incidence of credit card and identity theft crimes. Next, the PDPA and cybersecurity. I will explain about a review of cybersecurity. Before this, the corporate community's general understanding remained relatively slow. It was only a matter of time before a data user was charged under the PDPA. A few developments in Malaysia data protection and cybersecurity framework as a result of a Malaysian government publication of a Malaysian Digital Economy Blueprint (MDEB) in early 2021. As a result, the effectiveness of the Nation Data Protection and Cybersecurity Framework is coming under increased public security, and there have been calls for the government to strengthen the current legal framework for the data protection and cybersecurity. Alright, next, in this slide, I will explain about the PDPA 2010 cases in Malaysia. Okay, this one is recorded in one of the article, which date is May 2017. The first charged cases in Malaysia that be prosecuted under the PDPA are related to companies in the education sector. A corporation in the education sector was charged in early May 2017 under the Personal Data Protection Act 2010, or namely known as PDPA, for processing the personal data of former workers without a certificate of registrations. The maximum punishment is found guilty is an RM1,500,000 fine or up to 3 years in prison. Next, I will pass to the next presenter.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Mohamad Aiman bin Mohamad Napiah. I will present my part about Communication and Multimedia Act 1998, or we call CMA 1998, also called Act 588. So, the background of CMA 1998 is founded by fundamental principles of transparency and clarity, and more competition and less regulation. That's a bias to generate rules that regulatory forbearance and emphasis on process rather than content. So, administrative and sector transparency and industry self-regulation was supported by fallback regulatory standard and may be administered by Malaysia Communication and Multimedia Commission (MCMC). So, the objective of the Act is to offer the general set of regulatory regulation based on general definition of market and service activities. This Act also jurisdiction is limited to network service and activities. So, what the case that includes CMA 1998 in Malaysia? So, in October 2015, the case of Khalid is met under Section 223 of the Act for illegally commenting on Facebook. So he was charged with 11 illegal offences of the Act. So as well as 3 further violations of the Sedition Act, Khalid was subject to many penalties, including requirement to report to the local police station every 2 weeks. So that is first case that includes CMA 1998 in Malaysia. So the second case that includes CMA 1998 is happened in April 2016. In Kelantan, Muhammad Amirul was found guilty of 14 count of offence under Section 223 of the Act for illegally insulting of a member of royal family on Facebook. So they was intentionally sentenced to 1 year in prison, but it was later reversed and he was sentenced to years of reform school. So next case is happened in September 2016. Sidik Kamiso, a former journalist, he tweeted that a negative message about Harun Din. This is past spiritual leader. So the tweet was deemed derogatory to Islam, and author was arrested in Shah Alam under Section 223 of the Act. So he was re-arrested under Section 298 of the Penal Code for creating religious dissension after the charges were previously dismissed. So he still on the police bail. So the last case that includes CMA 1998 in Malaysia is happened in February 2016. So for the first time, MCMC or Malaysian Communication and Multimedia Commission used their power to forbidden website that carry content relating to Malaysia or MDB issue that happened in February 2016. So Malaysia Insider Team I, a famous online news service, was blocked by government on 25 February 2016. So also to add the facts, the MCMC also blocked news websites such as Sarawak Report and Asal Sentinel, and also ongoing intimidation and lawsuit against media outlets such as Malaysia Kini. So that's a case happened that includes CMA 1998 in Malaysia. So that's all from our team, our group, for the presentation, and thank you for the listening.